everyone, welcome to my YouTube channel Learn Commerce with Namita. I am Namita Mane. In today's session, let us try to understand what is breach of contract, the types of breach of contract and remedies for breach of contract. So let's start the session. So what is breach of contract? Breach of contract means to break the contract. Okay, breach means to break the contract. Now there is difference between discharge of contract and breach of contract. Discharge of contract means when the both the parties perform their obligation, performs their responsibility in the contract, and after performing the responsibility or obligation, the contract comes to an end. That is what discharge of contract. Breach of contract means the one party breaks the contract in between or refuse to perform the obligation or responsibility. That is breach of contract. Breach of contract means breaking the contract. Okay, so we'll try to understand a breach of contract. When any party to a contract, okay, so when any party to a contract refuse, okay, see, refuse or fail or does something which makes the contract impossible to perform is called as breach of contract. Okay, so if suppose any one party of the contract, that particular party refuse or deny to perform the contract, then it is called breach of contract, means that person is breaking the contract. So in the case of breach of contract, the party who does not, okay, in the case of breach of contract, the party who does not or refuse to perform his obligation means responsibility for what they have entered into the contract, if that responsibility is not performed or it is refused to perform, then that party is called as defaulting party. And whereas the other party, okay, to whom the defaulting party has said have refused, then that party is called as aggrieved party. Okay, aggrieved party. Now breach of contract, will take one example. Suppose there is A, okay, and B. There are two parties in a contract. So A and B enters into a contract, and the contract is of what? Selling the house. Now A sells house, okay. A wants to sell house to B for rupees. They want to sell a house, okay. This is the house. Consider that this is a house. So A wants to sell house to B for 10 lakh rupees. For 10 lakh rupees on 31st December. Okay, so on 31st December, A is going to sell house to B on 31st December for rupees 10 lakh rupees. Okay, for 10 lakh rupees, B is going to take house of A for 10 lakh rupees on 31st December. It was decided, okay, the contract was decided between A and B of house that A is going to sell house on 31st December to B, and B is going to purchase that house on 31st December from A for 10 lakh rupees. Now in between, okay, in between C is there, okay, in between means for 31st December there is lots of time, okay. So for example, A and B made the agreement on 1st December, so now they have 30 days in between to fulfill the right, okay, to fulfill the obligation of the contract. So in between this 30 days, C meets A, okay, C meets A, and he says that, C says to A that I will purchase your house for 15 lakh rupees. Okay, so C says that I will purchase A's house. Okay, C says to A that I will purchase the same house which you are giving to B, I will purchase for 15 lakh rupees. Now A decides, or A thinks that I am getting 5 lakhs more, so I will break the contract with B and I will make new contract with C. Okay, so what is happening here? A is what? A is breaking the contract. A is refusing to sell his house to B for 10 lakh rupees, or he is not performing his responsibility, or he is not completing his obligation for why he has entered into a contract with B. So A is breaching, means this contract between A and B has been breached. Okay, that means A has break the contract with B of selling the house for 10 lakh rupees, and he entered contract with C for 15 lakh rupees. Now in this case, okay, now don't look at C, he is the third person. Now A, the actual original contract was between A and B. So A has break the contract with the B. So A is breaking the contract. So A is called as defaulting party, because A does not or refuse to perform his obligation. A has said to B that I will sell you my house for 10 lakh rupees, but he is not performing his obligation, or he is refusing to sell his house. So A is called as defaulting party. Okay, and B means the other party to whom he has rejected, to whom he has refused to perform the contract. So B is called as aggrieved party. Okay, B is called as aggrieved party. So I hope you have understood what is breach of contract with the example, and plus who is defaulting party and who is aggrieved party. So next we'll see types of breach of contract. Okay, now there are two types of breach of contract. First is actual breach of contract. Okay, and second is anticipatory breach of contract. First we'll try to understand actual breach of contract. This is important topic, breach of contract, in exam point of view. In university examination there is one question like explain what is breach of contracts, types of breach of contracts, and remedies for breach of contracts. So this is important topic. Please listen this lecture carefully. So I was on types of breach of contract. So there are two types of breach of contract. First is actual breach of contract. Now what is actual breach of contract? If a party, okay, if any party, okay, if a party to a contract fails to perform his obligation, okay, I will repeat again, obligation means responsibility of that particular party to while for what he has entered into a contract. So if a party to a contract fails to perform his obligation under the contract in the stipulated time, or refuse to perform such obligation, then such breach of contract is called as actual breach. Okay, now we'll try to understand what is actual breach of contract with the help of example. Okay, now actual breach of contract means when the party to a contract fails to perform his rights, his responsibility under the contract in a stipulated time, or on the due date of that contract, or due time of that contract, then that contract is called as actual breach of contract. Now for example, Ram and Sham, there are two persons in the contract. So Ram promised to deliver a horse. Okay, Ram promised to deliver a horse to Sham. Okay, so Ram is promising to deliver a horse to Sham on 2nd December on the appointed date. Okay, so Ram is going to deliver a horse to Sham on 2nd December on the appointment date. Appointment date means, appointed date means 2nd December. Ram refused to deliver the horse. It is a case of actual breach, means that in the contract Ram is going to deliver a horse to Sham on 2nd December, but on 2nd December only Ram is refusing, okay, Ram is refusing to deliver the horse to Sham. So what is happening here means on that the bridge he is breaking the contract on actual date, okay. So that is called that is what actual breach of contract, okay. So whenever a contract is break on the actual date, or when the date the contract is to be actually performed, on that date the contract is breaking by the one party, then that contract is called as actual breach of contract. Second second type of breach of contract is anticipatory breach of contract. Now what is this anticipatory breach of contract? If a party to contract, okay, if a party to a contract before the stipulated time or before the due date of his performance, by word of mouth or by behavior, or makes his intention not to perform his promise, it is deemed to be anticipatory breach of contract, okay. Now actual breach of contract means on actual date the contract is breaking, okay. Now anticipatory means before the due date, okay, before the due date or before the stipulated time, if the contract is breaking, then that contract is called as anticipatory breach of contract. Now for example, okay, Ram and Sham, okay, so Ram and Sham, the contract was what? Delivering the horse. Ram is going to deliver the horse to Sham on 2nd December. But if Ram informs to Sham before 2nd December that he is not going to deliver the horse, so it becomes what? Anticipatory breach of contract, means he is breaking the contract before the due date, okay, before the due date, then it is called as anticipatory. So if Ram, okay, if Ram informs Sham before 2nd December, means if Ram informs Sham on 1st December or on 31st, on 30th November or 20th November, whatever the date may be, but before this date, okay, before the 2nd December, if Ram informs Sham that he is not going to deliver the horse, so it becomes what? Anticipatory breach of contract, okay. So and Ram sells the horse to the third person called Abhijit before that date, it in this case it is anticipatory breach of contract, okay. So I hope you have understood the types of breach of contract. Next is what? Remedies for breach of contract. Now these remedies are given to the person or to whom the contract has been break, okay, means aggrieved party is going to get the remedies for breach of contract. Now for example, A and B, okay, so A is going to sell the house to B on 31st December, as I have explained you this example in the previous slide, that A is going to sell the house to B for 10 lakh rupees on 31st December. But before selling the house to B, A sells the house to C. So indirectly A is directly what? A is breaking the contract with B. So A is what? Defaulting party and B is what? Aggrieved party. So this aggrieved party will get the remedies for the breach of contract. So what are the cases? In which situation or in which circumstances the aggrieved party can get these remedies for breach of contract? So first is what? Rescission, okay, or cancellation. You can call rescission is also called as cancellation of the contract. So when one of the parties to the contract, okay, when one of the party to a contract does not fulfill his obligation, then the other party can rescind the contract and refuse the performance of his obligation. Now cancellation of contract means when one party refuses to fulfill the obligation, then ultimately the other party can cancel or can terminate by doing his performance, okay. Now we'll understand this by one example. Now Mohan makes a contract. Okay, Mohan makes a contract to sell certain goods to Soham for rupees 10,000. Okay, so Mohan makes a contract with Soham to sell goods for rupees 10,000, and Soham promised to make the payment on the delivery. So when Mohan is going to sell the goods to Soham, and when Soham receives the goods, and immediately after receiving the goods, Soham is going to make the payment to Mohan. But if Mohan refuse, okay, now if Mohan refuse to deliver the goods, okay, at the promised time, then Soham can assure, or Soham can assume that the contract to terminate. Okay, so if Mohan refuse to deliver the goods, so ultimately Soham can also assure that the contract has been terminated, and whatever means Soham, in this case Soham is freed from his commitment to pay 10,000 rupees. Okay, so Soham can terminate the contract, or he also can refuse the performance of pay, not to pay the 10,000 rupees to Mohan. Okay, so this is what cancellation of the contract. Next is what? Suit upon quantum merit. Okay, now quantum merit literally translate, or literally means quantum merit means as much as is earned. Okay, quantum merit means what? Quantum merit means as much as is earned. Okay, so when one party, now what does suit upon quantum merit means? As much as is earned. What does it mean? When one party at the request of another, okay, when one party at the request of another does something or supplies some goods to the another party. So one party at the request of another party does something or supplies some goods to other party, and if the compensation for such goods or service has not been defined at the time of contract, then the law decides what should be an adequate compensation for such goods or services is called as quantum merit. Now for example, suppose it means that when one party at the request of other party supplies some goods to another party, and if the compensation is not decided means when the party enter into a contract and when the parties does not decide, okay, if suppose the contract breaks or if the contract breach, then what will be the compensation given by the both the parties to each other. If it is not decided, then the law decides, okay, what should be an adequate compensation to be given to the party. Now suppose if one party in between the contract, okay, if one party has completed few work and remaining work is not completed, and in between only the other party has break the contract, so whatever work the other party has done, so that party have the right to get the adequate compensation from the other party. Okay, so if it is not decided what compensation both the parties should give each other, then the law decides, and that whatever the law decide is called as quantum merit. Now for how much, okay, how much or what would be such compensation depends upon the circumstances of the case. So whatever the compensation is there, okay, whatever the law is going to give the compensation, it will depends on the case. Okay, so now for example, to understand the suit for quantum merit, we'll take one example. A promise, okay, A promise to construct a house for B in rupees 50,000 rupees. So A and B, there are two parties in one contract, and the contract is what? To construct the house. So A is going to construct the house for B, and after the construction B is going to give 50,000 rupees to A. So A promised to construct a house for B in rupees 50,000, and A started constructing. Okay, means A started constructing the house before its completion, means the house is not constructed fully, it is constructed half only, but before its completion B upgrades. Okay, means he stopped. Okay, he says A to stop the work. Okay, upgrades the contract and stop A from doing the work. Okay, so the house is not constructed properly, means the house whatever A has constructed is half, but A did not complete, means before the completion of that construction only B stops A that stop doing the work, stop doing the construction. Now in such case, okay, now in such situation A can sue for an adequate compensation for the work that he has already done, and can also sue for damages. Okay, now in such situation A can file, okay, A can claim for the compensation, means A can take money from B for whatever the construction he has uh, done of the house, so he can ask money from B. So that is what quantum merit means. If A has constructed half house, okay, means till this much if A has constructed, and to complete this area was not completed by A, but in between that only B stops A not to complete the work. So whatever work, means whatever house A has constructed, this much house, A can ask for the money. Okay, money means he can ask for the compensation from the B, means half work which whatever he has already done, for that he can ask for the compensation. Now this compensation the law is going to decide whatever the situation is. Okay, so we'll move to the next remedy, that is claim for injunction. Claim for injunction means it is a negative order. Okay, injunction is what? It is a negative order by the court that restrained a party from doing something. So it is a negative order by the court that retains a party from doing something. Now for example, there is a popular case, that is Warner Bro versus Nelson. So in the case of Warner Bro versus Nelson, so case is what? A film actress, okay, a film actress agreed to act. Okay, Warner Bro versus Nelson. Warner Bro is a popular film producer of Hollywood movies. So a film actress agree to act, okay, exclusively for Warner Bros for a year and for no other producer. So the film actress is going to work only for Warner Bros for a year, and in between this year she cannot work with other producer. But during the year, okay, but during the year she contracted to act for another producer, but during she had a contract with Warner Bros that she is going to only work with the Warner Bros only and with no other producer. But in the during the year she made a contract with another producer. So what in this case what means, now she uh, contract with another producer. Now what the Warner Bros can do? Warner Bros can take one order from a court. That order is like injunction order, and the Warner Bros can stop her from doing acting with the another producer. So Warner Bros can sue a case. They can claim they can file a case against her, and they can take that order from the court that she cannot act with another producer, she can only act with the Warner Bros only. So it was held, okay, it was held that she could be restrained by injunction from doing so. So it is a negative order which Warner Bros has given to the film actress. Next is claim for specific performance. Claim for specific. Next remedy is what? Claim for specific performance. Now, when in the case of a breach of contract, okay, damages are not deemed to be an adequate remedy, okay, the aggrieved party can sue the party in breach to carry out his promise. And this is the direction by court for specific performance of the contract at the suit of the aggrieved party. Now what does this mean? Okay, claim for specific performance. Now in case of breach of contract means to break the contract. Now when the contract is breaking, okay, so damages means whatever the loss has been suffered by the other party, so compensation means adequate compensation is not necessary. If that party, aggrieved party, says that instead of giving me compensation, instead of giving me money, do not give me money, please carry the promise whatever you have made. So that is what claim for specific performance, and this direction of to give the specific performance is given by the court, okay, if the aggrieved party has filed a case in the court. Now for example, to understand the claim for specific performance, there is the example A, okay. A is looking for a house in a locality for his residence. Now A is looking for a house in locality where he can stay, okay, where he can live, and he finds one house, okay. So he contracts with the owner B to buy the house. Now A was looking the house and he got the house, and the owner of that house is who? B, and he contracts with the B to buy the house, but later B refused to sell the house to A, okay. So A makes a contract with B to purchase the house, but later on B refused to sell the house to A. So in this case, okay, damage from B, okay, damage from B. Why? Because B is breaking the contract, okay. So for such breach of contract are not adequate remedy, okay, for A. So A says that instead of giving me the money for the losses which I have faced, please continue the contract, that continue to sell the house to me, okay. So the breach of contract are not an adequate remedy for A, because damage will not be able to have the type of house he wants in the locality. In such situation, A can appeal to the court for the specific performance of the contract. Means what this say, what is this? Because the damages, okay, damages means here. Now B refused to sell the house to A, but what he actually A liked B's house, that's why he is purchasing the house. So the adequacy, the remedy say adequacy is not sufficient for A, because whatever whichever type of house A wanted, he is going to get from B only, the locality. So instead of the adequacy remedy, A says to B that A can appeal in the court that B should continue the contract, okay. So that is nothing but claim for specific performance. Next is what? Claim for damages, okay. Now what is damages? Damages are a monetary compensation, okay. A claim for damages, suppose there is a huge loss or some injury, that is what damaged in a contract. So damage are a monetary compensation allowed to aggrieved party by the law for the loss or injury suffered by him for the breach of contract, okay. So what if the contract has been break, and whatever the loss or injury the aggrieved party, the other party has faced, to fulfill that damage, okay, there is given some monetary compensation. Means monetary compensation means money is being given to the aggrieved party to fulfill the loss, okay, to fulfill the injury whatever he has suffered during the breach of contract. The purpose for this, okay, the purpose for giving the damage is to help the party who has suffered a loss to retain the position, it had, which he had before the loss was imposed upon the party by the breach of contract. Okay, so to come back, to overcome the loss whatever he had before the loss, whatever his position was there, it should be overcome. So the damage is given in the monetary compensation. So for example, okay, for example, A promise, okay, A promise to deliver 100 cycle tires at rupees 50 each to B, okay. So A promised to deliver 100 cycle tires at 50 rupees to B on 1st May. On which date? On 1st May 2020, A says to B that I will deliver 100 tires of 100 tires at 50 rupees each. Okay, so 50 into 100, whatever the amount will be there, that amount B is going to give to A, but does not perform his promise on that day. Okay, so A promised to deliver 100 tires at rupees 50 each to B on 1st May. On 1st May, A denies, A refused to perform his promise, okay, on 1st May. In such situation, okay, in such situation, if the price of the tire on 1st May is rupees 55 rupees per tire, then B is entitled to claim damage at rupees 5 per tire from A and can sue, means can file for case for such damage in court. Okay, so A refused to give deliver the tires for 50 rupees each on 31st May to B. So now what B will do? B will take some other, B will go to other person for purchasing the tire, but on 1st May the third party from whom B is going to take the tire, he sells the tire at 55 rupees. Now A was selling at 50 rupees and the third person is selling at 55 rupees. So the difference is of what? 5 rupees. And this 5 rupees, who has to suffer? B has to suffer. Now why B will suffer? So B can file, okay, B can take this damage from A because he refused to sell the goods on 1st May. That's why B has to pay more extra 5 rupees to purchase the tire. So this 5 rupees per the damage which B is going to suffer when he is going to purchase from the third party, then B can claim this 5 rupees damage per tire from A, okay, and he can sue the such damage. So this is suit or claim for damages, okay. So these are the remedies for breach of contract which aggrieved party can claim. So I hope you have understood what is breach of contract, types of breach of contract and remedies for breach of contract. Thank you very much. Please subscribe my YouTube channel, like and share the video, and do not forget to hit the bell icon to get the latest notification. Thank you.